Okay, so please allow me to introduce myself. My name is Éneas Xavier. It's a pleasure to be here with you all. And we're just about to start a third panel on climate change, climate regime and human rights. I must confess, it's not an easy task to moderate such a panel right after the marvelous moderation led by Professor Blood. But here we are. We do have some 4 panelists in this panel. 2 of them are here. So I'll start with the panelists who are here. We have Yuri Alexander Romaña-Rivas, which he is a PhD candidate at McGill University, Faculty of Law, Climate Justice in the Inter-American Human Rights System, envisioning race-consciousness reparations for Black and Indigenous communities. So Yuri, I think you have a flash drive with a presentation, not? So please, if you wanna take the lead, you have the floor and it will be a pleasure to hear you. Thank you.
I want to begin by thanking the organizers. This is a great opportunity for me to share some reflections. This paper comes from a working partnership that we did between McGill University, Faculty of Law, and University of Montreal, Faculty of Law. We drafted an amicus brief that was submitted to the Inter-American Court on Human Rights in the context of the advisory opinion on climate change and human rights. In 2023, we made the submission, and last year we participated in the oral hearings in Brazil, and that's part of the inspiration for this paper. And another aspect that I want to consider, of course, is the jurisprudence of the Inter-American Court and the Inter-American Commission on this aspect. Okay, let's begin. My main argument, I want to begin by saying that what my main argument is that I argue that to effectively fulfill its role of contributing to addressing climate-related harms affecting racialized communities, the Inter-American Commission on Human Rights and the Court must incorporate the notion of race consciousness into its reparation rationale. Unlike colorblindness, racial consciousness embraces race thinking as necessary to promote racial justice. Thereby, the Inter-American system can set the basis for envisioning a climate justice agenda that can compel states to advance race consciousness reparations schemes or policies to help mitigate or adapt racialized communities to the effects of climate change. And what I'm trying to make this argument, part of my background is that I also work at the Inter-American Commission on Human Rights. So I'm aware of the influence that the Inter-American system has in many countries in the regions. So they have through the reparations order, they can shape laws, legislation, and policies at domestic level. So I think that encouraging the court to be more bold in their approach to reparations in the context of climate justice can somehow trickle down into domestic debates on reparation for climate-related harms, and that could be beneficial for racialized communities in particular. To develop my argument, this presentation is divided into 4 sections. The first is the Inter-American system and its function. Just for those who might not be familiar with the Inter-American system, I'm going to present just a brief overview. The second is the Inter-American system, Indigenous and Black communities, and environmental human rights. Here I'm going to try to share some of the standards developed by the Inter-American system for the protection of the environment and racialized communities. Third, the Inter-American Court and its inquiry into racism and climate change towards a race-conscious jurisprudence. And here, basically, I'm going to draw on our exchange with the court during the oral hearing and their questions about the connection between structural racism and climate change. And then I will share some final remarks or conclusion. The Inter-American system and its function. The Inter-American system is one of the 3 regional human rights systems that exist in the world. You might be familiar with the European system, which is the oldest, the African system that is the most recent, and then, or the youngest, and then the Inter-American system that is in between. in the middle. The Inter-American system has a robust legal framework, basically comprised by the American Convention on Human Rights, the American Declaration on the Rights and Duties of the Men, the 1948 Declaration, and you also had the OEA Charter, the Organization of American States Charter. And there are two main bodies of the Inter-American system. One is the Inter-American Commission on Human Rights, and then you have the Inter-American Court of Human Rights. The Inter-American Commission is based in Washington, D.C., and the Inter-American Court is based on San Jose, Costa Rica, in Costa Rica. Their work is interconnected. And I'm just gonna mention some of their functions. I'm not gonna go through all of that because that would be a lot. That would consume all my time. But basically, the Inter-American Commission is considered a quasi-judicial body, meaning it has legal functions and political functions. Its legal functions are basically two. It can issue merit reports, basically cases in which individuals or groups come before the Inter-American system alleging human rights violations, and the Inter-American Commission can adopt a report with recommendations. And if the state doesn't comply with the recommendation, depending on if the state has accepted the contentious jurisdiction of the Inter-American Court and is signatory to or is member of to the Inter-American Convention on Human Rights, the case might be submitted or may be submitted to the jurisdiction of the court. Another function of the Inter-American Commission is to issue precautionary measures in situation of seriousness, urgency, and need to avoid an irreparable harm. In terms of political monitoring functions, the Inter-American Commission can issue thematic reports, country reports, can issue press releases. Those are some of the overall functions that they have. The Inter-American Court has three main functions. One is to issue judgments. The second is to issue provisional measures. And the third is to adopt advisory opinions. Here, we're going to focus on advisory opinions today. And it's important for you to know that the work of the court is mostly depending on the work of the Inter-American Commission, because most of the cases that go to the court are submitted by the Inter-American Commission, and most of the precautionary measures submitted to the court also stem from the Inter-American Commission work. Similarly, the Inter-American Commission can submit requests for advisory opinions, and the states can do that. In the context of climate change, where the states have submitted, that's two states that submitted this request, the state of Colombia and the state of Chile. Okay. This framework has allowed the Inter-American system to develop what is called a corpus juris, a robust corpus juris for the protection of human rights in the Americas. And you can see there has been significant contributions in terms of collective reparations for Indigenous and Black communities, for protection of their ancestral rights, basically recognizing the right to collective property of these communities. Also in terms of environmental protection, in terms of transition from dictatorship to democracy, many areas of contribution. Now, let's focus on the Inter-American system and its role in supporting the rights of Indigenous and Black communities and environmental rights in particular. And here, I want to highlight that the main contribution of the Inter-American Commission has come in two forms. One, through the issuance of thematic reports and a public resolution on climate change. The first report that the Inter-American Commission adopted, or the most significant report that the Inter-American Commission adopted, was one called Indigenous Peoples, Afro-Descendant Communities, and Natural Resources: Human Rights Protection in the Context of Extraction, Exploitation, and Development Activities. Basically, in this report, this is a 2015 report. In this report, the Inter-American Commission recommended that states must guarantee that Indigenous and Black communities have access to reparations in case of violations that occur as a result of the execution on non-consulted projects. Okay. projects that, and that's very typical in Latin America, there are many projects that don't comply with the consultation process, and they ended up hurting this community. So in that context, there should be, or there must be, some reparations guaranteed for this community. Another report was issued in 2021, and it's called Economic, Social, Cultural, and Environmental Rights of Persons of African Descent. And basically, the court wanted to highlight, the Inter-American Commission wanted to highlight the connection between structural racism and the environmental harm that many communities of African descent, the descent experience in the Americas. And basically, they argue that to prevent that harm, the state should guarantee protection of their collective right to territories, and also to guarantee the access to a healthy environment. In 2023, the Inter-American Commission issued two reports, one called the Economic, Social, Cultural, and Environmental Rights of Indigenous Peoples and Tribal People of African Descent in El Salvador, Guatemala, Honduras, and Nicaragua. Another one called Poverty, Climate Change, and Economic, Social, Cultural Rights in Central America and Mexico in the context of human mobility or migration. Basically, in these reports, the Commission has stressed the importance of guaranteeing reparations to Indigenous and Black communities for any harm that they suffer as a consequence of development projects taking place in their territory. I could discuss them in further detail, but I don't have the time, and I can see Elias already signing me, putting pressure on me. The other presenter didn't have this pressure, Eneas. Come on, be a little bit flexible with me. So unfair. So unfair. Anyways, the other decision adopted by the Inter-American Commission is a public resolution on climate change in 2021. This is significant because in that resolution, the Inter-American Commission said that environmental harm is justiciable within the Inter-American Commission. Basically, that people could bring petitions before the Inter-American system alleging the violation of their right to a healthy environment. This is based also on the work of the Inter-American Court. And here I'm gonna make reference to the work of the Inter-American Court on the right to environment and climate change. And the Inter-American Court has made basically three main contributions. One, through the advisory opinion on the environment and human rights, a 2017 advisory opinion, basically highlighting states' transboundary responsibility for harms caused beyond their borders, and also the state's obligations to monitor and prevent environmental harm within their territory or their jurisdiction, and also beyond that, and the obligation to cooperate in good faith to prevent environmental harm, and also to observe the principle of precaution. Those are basically the obligations under highlighting that in that advisory opinion. And then we had the Oroya case, which is a case against Peru, where the court reiterated basically these principles, finding that Peru was responsible for the environmental harm suffered by the community of La Oroya, a very tragic case, and basically the state has failed to monitor and guarantee that the companies operating the site, the mining site, follow the science that were indicating that the people were at risk of the exposure of arsenic and other metals. And then we have the request for advisory opinion on climate change and human rights that took place in 2023, and in which we participated with the support of Professor Cohen, Professor Maigret, and others. And Éneas was also involved in that initiative. So from all of this, the standards that we can draw are the following. The standards set by the court can be summed up as follows. The state of origin responsibility for transboundary harm. That's a clear principle established within the Inter-American system. Responsibility to prevent environmental harm within and outside their jurisdiction by regularly monitoring and supervising activities that can significantly impact the environment. Third, the observance of the precautionary principle. Fourth, the obligation of interstate cooperation in good faith to prevent environmental damages. and the obligation to guarantee individual and collective access to information and public participation in decision-making process relevant to environmental issues. Then, based on the thematic reports by the Inter-American Commission, there are other standards specifically relevant to indigenous and Black communities, and they are the following: the state duty to prevent, mitigate, and suspend the negative impacts of extractive and development activities on the individual and collective. A state duty to recognize, respect, and guarantee indigenous and Afro-descendant communities' collective territorial rights and the enjoyment of health, environment, and natural resources. A state duty to offer reparation for the harm the indigenous and Black communities' territories have suffered because of the state's failure to uphold its obligation. A state duty to design or establish plans and public policies to deal with the climate emergencies, implications, and harms on the territory of indigenous and Black communities. This measure must guarantee the climate crisis doesn't affect or jeopardize the effective protection of the human rights of indigenous peoples and Afro-descendant people, tribal or peasant communities. Okay, those are basically, in general, the standards that exist within the Inter-American system. Now, my third point is the Inter-American Core and its inquiry into racism and climate change. And I have called it towards race-conscious jurisprudence. In our oral presentation before the Core, we asked the Core to recognize that climate justice must be understood as racial and ethnic justice in the Americas. We draw on the work of the United Nations Working Group of experts on people of African descent, the 2022 report on ecological crisis, climate justice, and racial justice by the UN Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. You might have heard of her, Tendaya Kume. And also the 2023 report of the Intergovernmental Panel on Climate Change that basically provides scientific evidence of the impact of climate change in places such as South America, Central America, indigenous community, local communities. To illustrate our point, we basically draw the attention to the core's attention to two situations. One was the situation of a Black community in the town of Pangui, municipality of Nuquí Chocó. And we said to the core that this community, because of the sea level, is about to disappear. And that's along the Pacific coast in Colombia. And we also mentioned the situation of the island of Carti Sucdupu in the Republic of Panama, where used to be inhabited by the indigenous community of Gunayala. This indigenous community basically had to be displaced beginning June 1st, 2024, and they became the first displaced community in the America from a complete territory. So that we wanted to refer that to the court to show the urgency of this situation. And then the court asked us, how could they deal with the issue of implicit bias or racism, above all when it is related to public policy in terms of legislation, judicial decision, administrative decision, that basically drive the determination on what type of measures are going to be determined to deal with climate change. Our answer was focus on racism as a structural phenomenon embedded in all elements of the social fabric, which contribute to the normalization of racism, making it seem invisible. And we draw on the scientific information available about the link between structural racism, colonialism, slavery that make this community more vulnerable and susceptible to the impact of climate change. Particularly, we draw on the special rapporteur report on what I just mentioned, the special rapporteur on contemporary forms of racism, in which she made reference to what is called sacrifice zones, which are zones mainly inhabited by racialized communities, where the devastation of the ecological crisis is felt disproportionately. But I'm about to finish. You are this strict policy is being inaugurated with me. And I'm joking, I'm joking. Don't worry, Eneas. I'm about to finish. I'm about to finish. But what I want to bring your attention to is the fact that the Inter-American Court has as many courts has done, has a practice of colorblind jurisprudence. Basically, the Inter-American Court takes the approach that the law is neutral, coherent, and objective. So the law doesn't need to be analyzed through the lens of race. And we can see this in two significant cases, such as the case of Hacienda Verde in Brazil, and the case of the work fire factories in Brazil too, where the issue of race was presented by the petitioner. The court looked at other factors and focused basically on class, poverty. However, the court has taken into consideration issues of critical race theory, but basically focuses on intersectionality. The court acknowledges the contribution of intersectionality to its jurisprudence, and it has used it to connect different factors of vulnerability, but it has been reluctant to link it to race. What we wanted to bring to the attention of the court is that race is crucial in this matter, and they should pay attention to that. And for that, basically, in this paper, I'm arguing that the court should adopt the notion of race consciousness, which basically means that we need to think about race openly when we think about how to address this solution, above all in legal discourse. And basically, to embrace race consciousness is for the service of racial justice. As we have Kimberly Crenshaw, who has said that this belief in color blindness and equal process, however, would make no sense at all in societies in which identifiable groups had actually been treated differently historically, and in which the effect of this different treatment continue into the present. That's true in the Americas too. We have identifiable groups that continue to be treated differently, or the effect of past injustices continue to be present today. So that justifies that the court revisit the way they approach their jurisprudence. And basically, in that regard, I draw on the court on jurisprudence to say that the court has been creative and deliberate in proposing reparation measures that try to address underlying causes of human rights violation, and they should do the same when it comes to race. And for example, they should take into consideration the notion of communities' life and dignified life. Basically, communities' plans and dignified life, which is a core element of the core jurisprudence, where they basically say that when it comes, for example, to territorial rights, the reason why that should be protected for indigenous and Black communities is because they have a specific attachment to this that guarantee the survival. So in the context of climate change, if you don't protect this, if you don't guarantee that the state are held accountable for the harm that environmental, the climate change can cause to this territory, you are basically sacrificing the future of these communities. And another element, and with this I'm gonna finish, is that the core should encourage that the state negotiate in good faith with communities, reparations for climate change. Because we know it's complex, but at domestic level, there is a possibility that the states can engage with this community that have been impacted and have been asking for help, but they should listen to this community and maybe not just to go and impose some measures. So I have more to say, but I hope I have opportunity to answer questions. Thank you.
Well, I must confess I have had the privilege to work with Yuri before, so I can tell you that 15 minutes is not enough. And not because he speaks too much, not at all, but because his approaches are fantastic and the content that he has brought is also passionate. But without further ado, I would like to invite Rachel Killean. She's a senior lecturer at the University of Sydney Law School, and the title of her presentation is Victims' Right, Transitional Justice and Lessons for the Climate Justice Debate. So, Rachel, do you have a flashpoint?
All right, excellent. Okay, so What I lack in depth and interest, I will make up for in gravity. So I am here under false pretenses. I don't have any climate expertise whatsoever. My background is in transitional justice, more specifically international criminal law, more specifically than that, victims' rights. But what I wanted to do today in order to justify being allowed to come here and learn from all of you is to share some of the lessons that I think can be learned from the field of transitional justice in the context of the climate reparations debate. Because I think what the climate justice and the transitional justice space share is the task of attempting to repair the irreparable. And so we can learn from over 3 decades worth of practice and scholarship from transitional justice, the field that has traditionally sought to respond to atrocity crimes, so genocide, crimes against humanity, political violence, those kinds of things. So what I want to briefly do, that's a bit small here, but that's all right, I'll tell you what it says, is I want to very briefly highlight what lessons I think can be learned with regards to victims' rights from transitional justice practice to date, focusing on procedural and then substantive rights. And then I thought I would highlight some new directions that are taking place in the transitional justice / ICL space that I think are also interesting for a climate reparations conversation. One of those is the recognition of other than human victimhood in Colombia. And then the other is the push to criminalize ecocide as an international crime. So this first part will be relatively brief because I actually think this will be familiar terrain for many folks. One of the key themes that has emerged through transitional justice practice and scholarship is the importance of a victim-centric approach. So often the climate reparations and the climate justice conversation can focus on the relationships between states. What do states owe to each other? Transitional justice allows for that recognition, but also focuses on what is it that victimized communities themselves need. And so through the evolution of the human rights framework and transitional justice practice, we have this emphasis on victim-centrism and participatory process in particular. So understanding victims' rights as being the right to exercise agency, the right to exercise voice, to access justice, to receive support in doing so. And this has a number of benefits. Of course, it's symbolic recognition of the fact that you were harmed. Probably you were harmed because you have particular marginalization in society. And so this can be recognition of your dignity. It's also, of course, key to ensuring appropriate outcomes. If you do not hear victims' voices, if the discussion does not include them in the room, then there's the chance that the substantive justice that is proposed will not reflect their needs. That, of course, has particular implications for those most often marginalized in conversations about the environment and climate. And then furthermore, by enhancing victim-centrism and participatory process, you ensure the legitimacy and the transparency of processes. So procedural justice theory would say that if you grant folks appropriate voice, if you hear from people, it increases the chance that they will respect the outcome of the process, even if that process's outcome is not what they might have hoped for themselves. I think that's a particularly important lesson in the climate space because by its very nature, there's more harm needing repaired than we can ever budget for. And to date, the focus on voluntary contribution has been a real limitation there. So if we're never going to be able to repair harm, the least we can do is ensure that folks feel that they were heard in the lead up to outcomes. So I think as well, transitional justice offers lessons on how to manage large numbers of victims, so traditionally it's sought to respond to crimes like genocide, where you might have thousands or hundreds of thousands of victims. We can see that that's only going to become more the case in climate, where we're potentially talking about millions of victims. But what we see in transitional justice process is attempts to get around this through forms of collective representation, through kind of trying to get the balance right between ensuring voice, as I've just been discussing, but also reducing kind of the load on the processes themselves. So for example, in the Khmer Rouge Tribunal, because I was just talking about it in the break, we have collective representation to ensure that thousands of victims are still heard from. A major theme in transitional justice scholarship and practice is how to navigate hierarchies. So how to ensure that women are heard from, how to ensure that racial minorities are heard from, how to grapple with the political hierarchies that exist not only between communities, but also within communities and within states. And then facilitating access to justice. Transitional justice has an extensive scholarship and practice in how do you use civil society in order to ensure that those who might not know that they have access to redress are able to access those rights. So in the context of substantive justice, transitional justice shows us I won't spend a lot of time on this because actually it's already been discussed, that you need to have multiple different forms of reparation. If we only focus on compensation, we're not actually responding to the full scale of the harm. So transitional justice has developed to recognize that you need symbolic recognition of harm, you need measures of rehabilitation, you need to recognize the psychosocial trauma that comes associated with harm, and that's also going to be true in the climate reparations space. We need to recognize the spiritual and cultural dimensions of harm, as well as the more pragmatic needs of victims. It also offers lessons in terms of balancing backward-facing repair and forward-looking guarantees of non-recurrence. So guarantees of non-recurrence are still relatively underdeveloped, including in the transitional justice space. But we can see that, for example, in South Africa, we had constitutional reform. In Northern Ireland, where I was based, we had police reform. We can look at lessons there as to how to put in place structures that reduce the capacity for future harm. Once we think about climate, obviously, we're talking about the end of extractivism. It's a much bigger problem, but nonetheless, there are lessons here. And then the final point I wanted to make about substantive justice is that TJ really shows that if you rely on voluntary contribution, then you have a problem. And we see that most recently at the ICC, the International Criminal Court, for their trust fund, which relies on voluntary contributions, is really not able to deliver on the reparation awards made by the judicial institution. So some important lessons there. All right, so just a couple of new directions I wanted to flag. So firstly, the expansion of victimhood beyond the human. So since 2019, the Colombian Jurisdiction Especial para la Paz has recognized a series of territories and ecosystems as victims of the conflict. So these include indigenous territories, territories of Black communities, and the Cauca River as well. What this does is open up the possibility of non-human victims being entitled to substantive and procedural justice in their own right. The notion of territory is not as limiting as rights of an ecosystem, because it also recognizes the relationships between the humans and the other than human in a territory, as well as the spiritual relationships between those things. But it can be understood as part of an ecocentric turn that also finds expression through rights of nature moves, through the criminalization of ecocide, which I'm going to turn to, and the rise of environmental restorative justice mechanisms. So what we see here is an emerging jurisprudence or attempt to engage with the interdependence of human and other than human harm, and therefore the requirements of human and other than human repair. And so there might be interesting lessons there for the climate justice discussion. And then finally, the move to criminalize ecocide, I think, has interesting points of connection with the climate reparations discussion. Now, again, this moves us away from state responsibility to individual responsibility, and there are a variety of challenges associated with this response. So the proposal, as you'll be aware, is to introduce a new crime at the ICC. There are also moves to criminalize ecocide in various domestic jurisdictions. There's also regional developments in the EU, for example. But a lot of the emphasis has been on the ICC. The challenge in terms of climate justice implications are, of course, that the ICC is a criminal court and therefore does not have retroactive application. So it's not ever going to be used to address the kind of key actors that have got us to where we are now. But that doesn't mean that the damage has stopped or that no one is committing acts that, you know, significantly contribute to the climate crisis today, tomorrow, and into the future. And so it offers an individual liability framework to address harm that is still to occur. There's a number of political barriers and legal debates around ecocide, but the debate is slowly shifting over the last 5 years from can this ever happen, to when will this happen? So it does seem like something that at some point is going to be on the cards. And what I wanted to flag is, I think, an often overlooked potential benefit of ecocides criminalization is the ICC's victim participation and reparations mandate. So although plagued with its own problems, what this allows for is victims of ecocides to have a participatory role in a judicial institution. It allows them to access reparations, whether or not they participate. And also importantly, the ICC's trust fund and victims, what do you call them? The victim organs of the court can offer assistance even in the absence of a final legal finding. And so there's pathways here. The ICC has practice in responding to environmental harm and connections between human and environmental harms, even in the context of its core mandate of atrocity crimes. And so there's the potential there for an additional avenue to repair. And that's it. That's it. I'm done. I told you.
Rachel, thank you so much for this wonderful presentation. And I must disagree with you. I think that, yes, you are a specialist in this subject and you have a lot to contribute with the climate debate. So actually, we are the ones who are learning with you. And without further ado, I'd like to invite our next lecturer. She's participating online. I would like to call Evelyn Lee Wang, lecturer at Northumbria Law School, Newcastle. The title of her presentation is Trapped in Dilemma, the Role of Human Rights Law in Addressing Climate-Related Harms.
Okay, thank you. Thank you very much for your very warm introduction, and also many thanks for the other presenters. Wonderful presentation. I noticed that we have got a presenter giving us some discussion on the inter-American human rights system, and also we are going to have another presenter on this topic. So today, my presentation is also involved with the role of human rights and climate change, but I will mainly approach it from the European Human Rights Tribunal. So first of all, yeah, okay, good. Just want to make sure that you can see all the slides very clearly. So I want to give you some background information. We all know that the International Climate Change Regime started from 1992 with the Framework Convention. However, because of some the disappointment at the slow pace and frustration of political negotiations. So there is an argument saying that we need to turn to an alternative. And this alternative is climate change litigation before international human rights tribunals. So here you can see I put a picture here, and this picture actually is a bit outdated. So because last year we had the COP29, yeah, so yeah, this needs to be updated. But anyway, it actually demonstrated the problem we are facing during the international political negotiations. So alternatively, human rights seems to be the solution. So from the Inuit petition to the Inter-American Commission of Human Rights in 2005, and also from the appointment of the Human Rights Special Rapporteur on Climate Change and Human Rights, and also recently the ICJ advisory opinion. So that is expected in this year. So from all of this, we can see that we are witnessing the right turn in the solutions to addressing climate change. So I want to briefly mention the kind of the hidden reasons why we kind of turn to the human rights solution. This is basically because the linkage between human rights and climate change. So we all know that climate change, especially the adverse effects, actually can implicate or violate a wider range of human rights. For example, the right to food, the right to health, or even the right to life, to house, and also fundamentally, this is because the human rights discourse actually, it enjoys absolutes and also universals. So it have some lexical and moral and pragmatical priorities, so it can empower people. However, in this paper, I'm not going to say that how great it is to use the human rights approach. I just want to calm everyone down and then try to identify the 4 pairs of dilemma. So I will address these 4 pairs of dilemma one by one in my following presentation, based on the high-profile cases that was happened within ECHR, European Court of Human Rights, last year. So first dilemma is the materialized violation, and also the that is what human rights law traditionally advocates, and also the imminent threat caused by climate change. So here we could see the dilemma, because, for example, human rights, it seems that it could only allow to prosecute until injustice has happened. However, climate change at the international level currently is mainly recognized as an inherently global threat. So here it's a threat, not a necessarily a human rights violation per se. So here there's a question, like to what extent the adverse effects of climate change can be recognized as a violation of certain human rights. So still in European Court of Human Rights, there are some traditions about environmental jurisprudence. So here they said that the criteria basically is, for example, a real and the imminent risk of harm to trigger Article 2. Here I want to say that Article 2 is the right to life. And then, or an exposure to a serious risk to trigger Article 8. So Article 8 is the right to privacy and the family life. So I want to say that in European Convention of Human Rights, there is not an explicit right to the healthy environment. However, the court has the tradition to interpret environmental dimensions from other existing, well-established traditional human rights. So basically, Article 2 and Article 8 are those rights that are frequently used by the court to protect the environment. However, this raises a question again, how imminent is imminent with respect to an imminent threat in the context of climate change? Because we just mentioned this is the tradition of the European Court of Convention, the European Court of Human Rights environmental jurisprudence. So it's not necessarily about the climate jurisprudence. So how imminent is imminent? So here I just want to introduce you with this case. So this case is a high-profile case last year. So it's the first case that has been addressed by the European Court of Human Rights related to climate change. So here, this is basically about a group of women, old women, senior women living in Switzerland. They just brought the case into the court, saying that Switzerland has kind of violated their right to life and right to family life or privacy, whatever, because the failure of the Switzerland's government to fulfill its obligations to mitigate climate change obligations. And then here, the court finally made the decision saying that Switzerland has breached its human rights obligations because it did not take sufficient action to mitigate the adverse effects of climate change. And also, however, in this case, the individual applicant's victim status was denied. And then the European Convention Court of Human Rights just say that if we want to afford the victim status in climate cases, 2 tests need to be met. The first one is the intensity or significance test, and then the second one is an urgency test. So both tests need to be made if individuals want to bring their claims and then want to have their case to be heard at the court. So why the court just set such a higher threshold to give victim the status? The other way, try to say that to address relevant climate change. So such an especially high threshold for applicants is basically to want to avoid a vast number of persons claiming victims status as a result of the global and the general nature of climate change. So here we could say that the court actually, they realized that the individual victims status cannot be granted easily because of the nature, and actually they failed to understand actually climate change will consist human rights violation in every case. So they intentionally have such a high threshold. And then the second dilemma is the vertical duties and the horizontal harm. So here, human rights law traditionally, it's kind of only the obligations are owed by the state to those citizens or those people within its own jurisdiction. So it's not that much related to extra territoriality. However, climate change is a horizontal issue. Climate change, the greenhouse gases emissions, it can come from every state, and also it can affect every corner in the world. So actually, in our previous presentations, we have addressed like the International American Court of Human Rights advisory opinion. So in that, so the court just identified the state obligation to prevent transboundary environmental damage. However, here I want to highlight that environment, that is in the context of environment, transboundary environmental harm. However, here in the climate change harm, the European Convention of Human Rights, actually, they just said that jurisdiction under the convention is primarily territorial. And this is related to a case. So the case is the Doherty case. So in this case, a group of 6 children and young adults, they just argued that the Portugal and the 32 other signatory states had breached the ECHR by failing to cut greenhouse gases. However, the court just said that, okay, your case is dismissed because you, first of all, we lack the kind of jurisdiction. And also second of all, it's kind of you haven't exhausted domestic remedies. But here, I just want to emphasize that the ECHR, the European Court of Human Rights, basically just want to say that, still territorial jurisdiction. So the third dilemma is that individual nature and collective solidarity. So human rights, we all know that it's kind of based on liberalism. So individualism want to protect individual like dignity and also the liberty. However, climate change is recognized as one of the most pressing collective action problems of modern times. So actually, I do not want to deny that there is a paradigm shift to incorporate collective dimensions into human rights law. For example, like the recognition of the right to the healthy life in 2022. And also we have like academic commentator said that the right has unavoidable collective dimensions. So made limited sense if one insists on trying to shoehorn it entirely to an individual rights template. And also in the recent case in the European Court of Human Rights, so the local standing, the standing actually to claim human rights violations was granted to the applicant association. Just in the climatiques case I just mentioned before about the Switzerland case, so a group of senior women and also some individual applicants. However, the standing was only granted to the association. So you could argue that actually, so because the association on behalf of its members, so it's kind of representing collective interest. So where witnessing kind of the relaxation of the standing to incorporate the collective dimension related to climate change. However, there is also some concerns saying that will this kind of break with the basic nature and purpose of the European Convention of Human Rights designed to protect individuals' rights. And also there is some argument saying that because individual behaviors beyond national borders may not be that feasible, because after all, the states, they remain the principal subjects under international law. So next one, the last dilemma is the legalistic nature and politically contentious nature. So the first, human rights is a legal instrument. So we know that it's kind of law, so it enjoys legalistic nature. However, climate change, traditionally, it is viewed as the political issue due to the polycentric feature. So climate change, we know that it kind of involves lots of factors and affects multi-dimensional, like either people and also non-human victims, so all of that. So it's quite multi-dimensional and polycentric kind of affect a huge social effect. Just the factors. However, just in the climatiques case, the European Court of Human Rights, they say that this does not exclude the possibility. It says that although, traditionally, climate change is viewed as the kind of political issue, and also maybe because of the separation of powers, like the parliamentary, the political branches, they may enjoy the legitimacy of because they are democratically elected, so they could make decisions that affect such a wide range of people and of social factors. However, the court just said that this does not exclude the possibility that where complaints raised before the court related to state policy with respect to an issue affecting to the convention rights of the individual or group of individuals. So here, the court just said that climate change is no longer merely an issue of politics or policy, but also the matter of law. And also the court went further, saying that the question is no longer whether, but how human rights courts should address the impact of environmental harms on the enjoyment of human rights. So yeah, while the court decision has received applause, however, there are still some concerns. There are critics saying that does this go beyond what is legitimate? And also, will this consist of judicial activism? And actually, after the court decision, the Swiss government, the parliament, they had a vote trying to kind of recognize that this ruling is not kind of valid. So finally, my conclusion is that the European Convention of Human Rights kind of working on the judicial tightrope. So on the one hand, they want to develop some new doctrine to reflect the nature of the global climate change challenge. And also in the meantime, they want to maintain the status of human rights protection instrument to kind of living instrument to incorporate the updated environmental issues. However, I want to say that human rights law actually is not a silver bullet. So we can turn to that, but that definitely is not the alternative. So it could only play the complementary role. So we still need to rely on political negotiations at the international level. Yeah, okay, so that's basically my presentation. So I know.
Thank you. Alexandra, do you have a presentation on slides?
No, I don't.
So please feel free, the floor is yours.
Great. Well, thank you so much, and good afternoon, everyone. Thank you for inviting me to speak to discuss my paper topic, and to the organizers for putting together such an insightful conference, and for all of you attending in person and online. So I'm a human rights lawyer, and my work has focused on forced displacement, conflict settings, and humanitarian operations. And it was following a legal clinical project with a local organization in Somalia that focused on the climate and conflict nexus that I started to look at this question of climate-induced displacement, and wanted to see if human rights frameworks had been used as a basis for litigating these issues through a human rights-based approach, which is essentially the focus of my paper today. So as the climate crisis exacerbates inequalities worldwide, the call for reparative justice for vulnerable communities has gained significant momentum. Today, I'll discuss how international human rights law can support and strengthen claims for climate reparations, focusing on the fundamental human rights to life, health, and the adequate standard of living. And my paper is structured as follows. So I'll discuss the legal foundations for climate reparations. Then I'll look at some real-world cases where human rights law has been used in climate litigation, and then assess the gaps and reforms that are needed to turn moral imperatives into enforceable rights. So let's begin with the legal framework. Climate change, as you all know, isn't just an environmental issue. It's obviously a human rights issue as well. There are key international instruments such as the Universal Declaration of Human Rights, the International Convention on Civil and Political Rights, and the International Covenant on Economic and Social and Cultural Rights that protect rights that are directly threatened by the climate crisis. So these include the right to life as enshrined in Article 6 of the ICCPR. This right is jeopardized by heat waves, floods, and famines. We then have the right to health, which is under Article 12 of the International Covenant on Economic and Social and Cultural Rights. which can be undermined by things such as air pollution and climate-driven disease, and then the right to an adequate standard of living, which can be found in Article 11 of the same international covenant. And this includes access to food, water, and housing, rights that have all been compromised by environmental degradation. Moreover, UN bodies have increasingly recognized these links. We have, in General Comment 36, the Human Rights Committee has affirmed that states not only have negative obligations to avoid causing harm, but also have positive obligations, which is to protect people from foreseeable environmental threats. So this framework creates a legal basis for holding states accountable when their inaction or harmful policies lead to climate-related human rights violations. To illustrate how this has played out, I will provide some examples of cases that have tried to use human rights law to address climate change impacts. So the first one is the Ion Tetiota versus New Zealand case from 2020. In this case, Tetiota, the claimant, was from Kiribati, had argued that sea level rise threatened his right to life. And while the court didn't grant him asylum, it recognized importantly that climate change could, under certain conditions, justify protection from deportation. So this was viewed as a milestone because it was the first time that a UN body had acknowledged climate change as a basis for non-refoulement, which is a fundamental principle of international law anchored in the Refugee Convention that forbids a country from deporting any person to any country in which their life or freedom would be threatened on account of race, religion, nationality, membership of a particular social group, or political opinion. The second case I want to highlight is the Torres Strait Islanders versus Australia case from 2022. In this case, Indigenous islanders brought a complaint to the UN Human Rights Committee, arguing that Australia's climate inaction violated their rights to life, home, and culture. And in this case, the committee ruled in their favor, making it the first time a state was held accountable for climate-related human rights violations against Indigenous peoples. Third is the Veren Klimaseniorinnem versus Switzerland case, which Evelyn discussed. Since she discussed it, I won't discuss it again, but I would just like to point out that this ruling from the European Court of Human Rights solidified the notion that climate change is a justifiable human rights issue under the European Convention. The other case is the Ugenda versus the Netherlands from 2019. This was, in this case, the Dutch Supreme Court ordered the government to reduce emissions to protect citizens' right to life and private life. And this case set up an important precedent because it was essentially a domestic court can enforce international human rights standards on climate. We also have the Milieu Defensie versus Shell case, a case from 2021, also in the Netherlands. And this court ordered a Shell company to cut emissions, citing human rights law. And so in this case, it expanded responsibility to not only states, but to corporate actors as well, showing that human rights obligations aren't just for states themselves. And finally, the Garifuna case versus Honduras from 2015. This was a Inter-American court case in which the court ruled that the Honduran government violated the Garifuna community's rights by failing to protect their ancestral lands. And the case emphasized the importance of territorial reparations and highlighted how state inaction can perpetuate environmental harm and other human rights violations. And so together, these cases try to do is illustrate how human rights law is already being used to challenge inaction and secure remedies, but also show, obviously, the limitations of the current systems that we have. And so despite progress, key gaps remain. First, there's no binding obligation for reparations in international human rights law. States may be found responsible, but they're rarely compelled to compensate. Second, when it comes to climate-induced displacement, this remains largely unprotected. The 1951 Refugee Convention doesn't recognize people fleeing due to climate threats. And although there might be some forms of protection, such as in the US, temporary protective status, or other forms of protection, they tend to be temporary in nature and not sufficient to meet the demands of all those who are going to have to flee due to climate change impacts. Third, we see fragmented jurisprudence, so different courts applying different standards, which then creates inconsistency and legal uncertainty. And then fourth, there's no clear global mechanism for calculating or distributing climate reparations. And so this leaves the process ad hoc, dependent on negotiations or litigation, rather than it being something that can be grounded in law. And so how do we move forward? So first, I think we need to integrate climate reparations into existing human rights treaties. This could mean maybe amending the International Covenant on Civil and Political Rights or the International Covenant on Economic and Social and Cultural Rights to explicitly recognize environmental harm as a rights violation, or creating a new climate protocol under the Human Rights Council. Second, we need a dedicated adjudicatory body. So this would be an international court or tribunal with the power to hear climate-related human rights cases and then have the capacity to award reparations. This would have to also be supplemented with some kind of a fund. I know that there's the loss and damage fund, but unfortunately, year after year, we see that marginalized communities try to advocate for increased funding to the fund, and yet those needs haven't been met. Third, we need guidelines potentially developed by the UN to maybe standardize how reparations are calculated and then delivered. And this should include financial compensation, rehabilitation, restitution, mitigation or adaptation efforts for those who are being displaced, and guarantees of non-repetition. And fourth, legal pathways for those displaced due to climate change impacts. Further legal pathways should be developed as these individuals need protection, legal status, and pathways to resettlement. And finally, affected communities must be at the center. Reparative measures must be community-led, culturally appropriate, and grounded in the needs and knowledge of those most impacted. And so in conclusion, international human rights law, I think, offers a powerful foundation for demanding climate reparations, but it's not yet enough. As the cases I've discussed have shown, courts and human rights bodies are increasingly willing to acknowledge the link between climate change and human rights, but recognition is just the first step. We need systemic reform, we need enforceable obligations, inclusive mechanisms, and a commitment to justice that extends beyond just the courtroom. And so above all, we need to center the voices of those most affected and ensure that the harms of climate change are not just acknowledged, but remedied. So I thank you for your attention, and I look forward to the discussion.